Let's talk about when a person is eligible to file for a divorce in North Carolina. We have a 1-year separation requirement. It is one of the longest separation requirements of all the states in the United States. Under North Carolina law, you are not eligible to file for divorce until you and your spouse have been separated for 1 year and 1 day. In other words, if you separate on January 1st, you cannot initiate an action for absolute divorce until January 2nd of the following year. Now, that doesn't mean that you can't take care of the other claims earlier than that. As soon as the parties physically separated, it is very common for them to go ahead and start negotiating matters such as child custody, child support, post-separation support, alimony, and equitable distribution. So you can go ahead and get all of those claims resolved immediately, but you are not eligible to file for absolute divorce until you've been separated for 1 year. And that 1-year requirement is non-negotiable. Now, some people have asked me in the past, is it possible that we just kind of tell a fib and tell the court that we agree that we've been separated for more than a year? That is not possible, nor is it advisable. First of all, as an officer of the court, I cannot, and nor can any other attorney, advise you to commit fraud upon the court. So I always tell clients there is no fibbing about the date of separation. It is what it is, and you have to wait the full year. The legislative process behind this rule is that the legislature wants to give the parties a full year to explore and consider reconciliation before they get an absolute divorce. An absolute divorce is the very last step of the process. First, the parties will separate, then they will resolve all of their marital claims, whether that be custody, child support, PSS, alimony, equitable distribution, and any other claim that may exist. And then the divorce will be the very last step in the entire process.